Hello, welcome for joining. Okay, today we're going to talk about 11 tips on how to make a good Spanish will. We're going to cover, do I need a Spanish will? Why do I need a Spanish will? What happens if I don't make a Spanish will? What we can achieve with a Spanish will that's well written, and finally, the 11 tips for making a good Spanish will. And when we finished with those, we're going to give you two bonus tips with a couple of other things that we recommend that you do to make sure that your beneficiaries have no problems the day that they are called to inherit. Okay, so we're going to go straight into a keynote presentation where it's going to be easier for me to follow through and make sure I don't miss anything out. Okay, let's see. Okay, so as we said, let me just make this a bit larger here. Let's see. Okay. Okay. So what we're going to talk about is the first thing is that the webinar that we're going to do now, which is being streamed live on Facebook, is the webinar is aimed at people that have assets in Spain. Okay, if there's no assets in Spain, of course, this webinar is going to be a waste of time for you, so you don't need to see it. As all the way through, we're going to explain, it is very important to have a Spanish will, and as I state here, we enjoy the challenge of handling complicated probate cases for expats, but this is not in your interest. The webinar is about keeping inheritance simple. Okay, now that you know what the problems that we're going to try and resolve with this webinar, let me just introduce myself. I'm Michael Davies. I'm a Spanish lawyer. I've been handling inheritance and probate for expats all over Spain for over 25 years. I'm not bragging, I'm just explaining this so that you know, so that you feel comfortable that I know what I'm talking about and it's worth listening to this advice. Okay, so let's dive straight in. Okay, the first thing is lots of people have doubts. If I have assets in Spain, do I actually need a Spanish will? Okay, well, I'm trying to make it categoric for you. This is my advice. Here it is in writing. If you have a property in Spain, you should sign a Spanish will. Okay, that's I say here. That's something that I say, and all lawyers that I know of here in Spain that deal with the estates of expats here. There is no doubt. Okay, it is recommendable to make a Spanish will. In case there's any doubts, I'm just going to now explain on the next slide very quickly what happens if you don't make a Spanish will. Okay, so we can be in different scenarios when there's no Spanish will, and that is one, that there's no Spanish will, but you did make a will in the UK in reference to worldwide assets. Okay, the problems can be many, but let me just sort of explain a best case scenario, and then everything else could be worse than that. The best case scenario, there's no will in Spain. First, we have to prove to the Spanish system that there is no Spanish will, so we have to request a certification from the central register. They prove that there's no Spanish will, and then we've got to then work out whether we're intestate or whether there's a will in the UK that could be used in Spain. Okay, if there is a will in the UK, that will would never be directly, you can never validate it directly for use in Spain. You'd have to go to probate in the UK. And once you've got probate, then your Spanish solicitor will give instructions to the English solicitor of how the approach that we need to take to get it convalidated. Basically, this is Hays Apostle, official translations, a series of things, sometimes a certificate of law, there's something in the will that's not clear to the Spanish system. But immediately we normally have problems because the English will may mention the word trust, for example. Okay, that is very difficult. It causes lots of problems in Spain because trusts as such don't actually exist over here, and therefore the convalidation is very complicated. It also creates, in all cases, very serious delays, and the actual inheritance procedure is much more expensive. We always say that to wind up an inheritance with no Spanish will, in an absolute best case scenario, the solicitor's fees are going to probably be double. There can also be very serious problems with inheritance tax, because in Spain, the beneficiaries pay more or less inheritance tax depending on their relationship with the deceased. For example, spouse and children, Andalusia, are entitled to €1 million each. What happens when you name a trust? Well, if, for example, the trustees are not an immediate family, but the beneficiaries are the children and spouse, the Spanish system may consider that if those trustees have actually got the ability to sell assets and dispose of assets or access money and things like this, they may consider that they won't accept the claim by the final beneficiaries of the high exemptions, because in reality it's the trustees that can access the money and not the beneficiaries themselves directly. It's a long story. There are lots and lots of problems with all this. Just make Spanish will. Also, the English will, when you're a lawyer in the UK, makes it. He won't be thinking about Spanish inheritance tax because he's thinking along the English lines. Exceptionally, you can be in a situation where you end up in an absolute mess and the will from the UK can't be convalidated, and you have very serious problems. You could even be in a circumstance of not being able to wind up the estate. I've never seen one go that way, but we have seen probate procedures that go on for 3 or 4 years and are incredibly expensive because, amongst other things, the reasons I just mentioned. What happens when there's no will anywhere? Okay, that's another possibility. Well, first thing is we have to prove there's no Spanish will. Once we prove that, if the deceased was resident, we go over an intestate procedure in Spain. It's long, it's expensive, and of course the beneficiaries will be those that are established by the Spanish system. In Spain, it's the children that get the lion's share and not the spouse. Okay, if the deceased was not a resident, then we can't handle an intestate procedure in the UK. You'd have to handle an intestate procedure in Spain. You have to have an intestate procedure in the UK, obtain letters of administration, and then convalidate, and that again causes lots of problems. Okay. Another situation we can be, there may be a Spanish will, but it's badly written. This can happen as well. The biggest problem at the moment, the one that comes to mind, is wills that are not compliant with Directive 650/2012 that came into force in 2015. Everyone was given 3 years to update their wills. What basically happens? Well, Directive 650/2012 says that if you die in Spain and your Spanish will does not say that you specifically wish English law to rule how your estate is governed, they will automatically apply the system of Spanish obligatory heirs. Now, where is the problem? Well, an English person can make a Spanish will, leaving everything, for example, to their spouse, and as a second step down to the children, the normal way. They just have to put the clause in saying that they choose their English law to determine how they are allowed to distribute their estate, which allows them to do whatever they want on their Spanish will. If they don't say that, and they were resident, the obligatory heir clauses apply. The problem that in Spain, that means that instead of your wife receiving let's say half your villa and half the money in the bank account, receiving your estate, as would happen in the UK, even if you said so on the will, that won't actually happen. The children would receive 2/3 of your estate and your wife a little more than 1/3. In fact, the children receive a little less than 2/3 and your wife a little more than 1/3. But of course, it's a problem because then they need the authorization from the children to be able to sell. And of course, this can get much worse if there are children from other marriages and this sort of thing. Again, in other words, always make a Spanish will, and if you made a will that was signed before 2012, then you will need to update it, go to your solicitor or come to us and we'll write a new one revoking the previous one. If you Google, have any doubts about this, Google Directive 650/2012, why do I need to make a new will? And you'll see almost all the solicitors that deal with expats in Spain have written about this at some point or another between 2012 and 2015. Inheritance tax problems when there is no Spanish will. Well, we've touched this before, so that's that, and many other problems. This is just an idea of the different problems that can occur if there is no Spanish will, but there are many, and we could go on all day. We handle lots of complex estates which have derived from people not making a Spanish will. That's what we specialize in. And even though we like the challenge, it's not in your interest. In your interest, make a Spanish will, keep things simple and much less expensive to wind up the estate. Okay, now that we've spoken about the negative things, let's talk about the positive things. What things can you achieve with a well-written Spanish will? The first thing is to protect the people you love correctly, okay? In other words, you'll be speaking to your lawyer, to us, or another lawyer that deals with these matters, and you can explain exactly what you want to achieve, and they will write up a will that achieves just that, avoiding the risks of claims from third parties and things like this. For example, they would make sure that the clause to comply with Directive 2012 is well written, so that, for example, the children can't claim against the surviving spouse, or they can simply stop the inheritance in its tracks because it's not mentioned correctly. Also, there may be situations that are a bit more complex, where, for example, you're married to your second spouse and she has children from a previous marriage, and you want to make sure that your spouse is able to live in the property, but at the same time, your children from your first marriage end up inheriting the property at the end of the day. There are ways to sort all those things out, which is not with a trust like in the UK, but we have our own systems here in Spain, and your solicitor will be able to explain all these things to you. Now, if you have a Spanish will that's in normal and good order, basically probate could be finalized very easily within 3 or 4 months. In our case, we guarantee that all our wills we could get take probate on them within 4 months, including registration of the real estate and everything else. Inheritance tax efficiency. Okay, if you go to a Spanish lawyer, they will explain the different exemptions in different regions of Spain. Andalusia has one set, Valencia has another, and he will make sure that you pay the least possible amount of inheritance tax. In Andalusia, this is very easy nowadays, because spouse and descendants are each entitled to €1 million tax-free. So even, for example, if you had a villa in Marbella worth €2 million, as long as you divide it between your spouse and your 2 children, they could each claim €1 million, and it will be tax-free. But even above the 1 million, the spouse and children, they have a 99% deduction in any case. So in Andalusia, as long as you've got wife, children, and those are the people that you want to inherit, it is very, very easy to avoid the inheritance tax. Avoid claims against the estate, which is what we've mentioned before. The problems with the system of obligatory heirs. I keep saying this because we're seeing a lot of problems due to wills that are not compliant with the directive. Okay, avoid conflict between the English and Spanish will. I mean, this is not rocket science, but believe it or not, we see this problem arise. In other words, someone comes to Spain and you just have to take a minimum precaution. If you make a will in Spain, you need to say on it that it's limited to the assets in Spain. Why? Because otherwise you'll automatically revoke the previous will that you made in the UK, and you don't want that. You want the will in the UK to handle the English assets and the assets in Spain to be dealt with under the Spanish will. The less the two systems cross, the better. It happens the other way as well. Sometimes someone will make a will in Spain And then later on, they make another will in the UK, forget to tell the lawyer in the UK that they've got assets abroad and they're going to deal with them under a Spanish will, and they go and make a will in the UK saying that they refer it to worldwide assets. And as it's a later will, it revokes the Spanish one. Most solicitors, as long as you explain things correctly to them, they'll be able to avoid this without any problem at all. It's just a question of having a word with them and making sure that all this is tied up. But I'm saying these things because I've seen them, okay? So it does happen. Okay, and finally, let's go for the 11 tips for a good will. Now, different circumstances may require that some people need a will that is more thought out and more complex, and we do lots of these wills. But for 99% of expats in Spain, those that own a property and a bank account and maybe a car and have an intention initially of leaving things to each other and then perhaps down to the children, or in slightly different percentages, this advice here works well. Okay, and it will avoid, if you follow these 11 tips, you'll avoid most of the pitfalls that exist. Okay, so the number one tip is to not underestimate the importance of signing a Spanish will. Okay, it doesn't matter how many times we say this, and most of the lawyers that we know say this as well. There are still some people that buy a property in Spain and don't make a Spanish will. That's a big, big mistake. It doesn't happen very often nowadays because most lawyers that handle the conveyance will also offer to make a Spanish will, and normally they sign it at the same time that they handle the conveyance. But from the old days, those that purchased 15 years ago, 14 years ago, 20 years ago, we still handle many estates with no Spanish will. And it's a shame because it doubles the expense. It often leads to very high inheritance tax. It's not the right thing to do. And it also, because of badly written wills, we see a lot of claims from children against second wives and second wives against children, and all because the will was not correctly written. Okay, so number two, if you already have one, make sure it complies with the EU Directive 650/2012. Okay, this is what we've mentioned before. So if you've made a will that was signed before 2012, it will definitely not be compliant, and you need to go and have a word with your lawyer to see whether in your case you need to make a new one revoking the previous one. If the will was signed after 2012 but before 2015, I'd still just have a quick word with the lawyer that prepared it just to make sure that he was aware of the directive, because everyone was given 3 years to adapt wills. That first year after the directive was approved, not all lawyers in Spain, especially those that don't deal with inheritance too often, were actually aware of it. Just have a quick word with him. Is it compliant with directive? Okay. If you have children from other marriages, it's perfectly possible to protect both your wife and your children by using life possessions, etc. Okay, well, this is something that comes up quite a lot. And in Spain, there's a perfect system, for example, to protect your second wife so that she can keep living, she can continue to live in the villa in Marbella or in Marca or wherever you are on the coast, while at the same time making sure that your children will end up receiving that estate after the second death. You can't do it with a trust like you would in the UK, but here we have a system where we divide up the ownership between what's called the life possession and the residual or final ownership. It's very straightforward, and it's a very good system that we've used many times over the year. We think that there should be more people that use this system. Okay, making sure that you understand the advantage of sentence 3rd of September 2014, European Court of Justice. Okay, well, this is simply that up to 2014, non-resident beneficiaries had a terrible deal with the tax office because they weren't allowed to claim the regional exemptions. Since then, they are allowed to claim the regional exemptions, which are different in each region of Spain. Andalusia has very generous ones. We'd have to go, depending on where the assets are, we'd have to look at that carefully. Now, the reason I say this is that, of course, in the old days, before that sentence, lots of clients needed wills that were slightly more complex, and maybe we divided up the assets between more beneficiaries because we were trying to avoid what was then going to be a very serious inheritance tax bill. Those clients that traded off, if you like, an easy winding off the estate in exchange for, in other words, they made their wills more complicated to save a lot of inheritance tax, but now maybe that complication isn't needed. So since if you had a will that did anything complex before 2014, have a word with your lawyer, because that trade-off that you did, maybe it may not be necessary anymore. So for example, maybe you divided up your estate between your wife and 7 grandchildren and all these things to try and avoid the very high inheritance tax. And now, because the allowance is €1 million and 99% deduction after that, you could now go back to your lawyer and say, believe everything to your wife without having to worry about inheritance tax. Just be aware that we prepared many wills that to avoid the inheritance tax, we did things more complex than would be necessary right now. So if you did a will before 2014 with complex clauses to avoid inheritance tax, it may be time just to have a quick word with your lawyer again. We talk about the use of a sensible use of life possessions and residual values as a way to mitigate inheritance tax. We spoke about that before when it was a question of protecting wife versus children of other marriages and vice versa. It's also useful for inheritance tax. Okay, the other thing is, be aware that in some regions, be aware that in some regions of Spain, exemption rates have been reduced or abolished, but in others, they've actually increased inheritance tax. We've had 4 changes to the inheritance tax exemptions in Andalusia in the last 7 years. Now, all that in Murcia, they've done 2 changes. In the Valencia region, they've done 1 change. Okay, this basically means that if you've got a will that's over 5 years old, it's a good idea that you have a word with your lawyer to see if it's still in good order. Just make sure the will is sensible from the point of view of inheritance tax. In other words, if you did a will without even contemplating the issue of inheritance tax, take a second look at it and just make sure that it is efficient. This is more important if your estate is large. Okay. Don't make a will. Okay. Do not make a will that is unnecessarily complex. Okay. I personally have dealt with over 400 inheritance procedures since I set up my office in 1994, and I have come across some very complex wills that were made that way unnecessarily, and I never quite understood why they'd be made in that way. Sometimes they were sold by financial companies that were selling financial products at the same time, and there's a slight conflict of interest that led them to have very complex situations. So if your lawyer sells you a will with complex clauses, you need to understand exactly what they're trying to avoid. I say this because in Spain at the moment, inheritance tax in most regions is very, very low or non-existent for spouse and children. So if you've got a complex will with complex clauses, have a second opinion on it. Never mention a trust on a Spanish will. Okay. As I mentioned before, if you've got no Spanish will, you've got an English will that mentions a trust, it's a disaster to convalidate. But we've even come across people that have made a will in Spain, and they've obviously told their lawyer or whoever was advising them to mirror their English will. And the person that's written their will has mentioned the word trust in it, And sometimes maybe the notary didn't pick it up either, or he just sort of thought he didn't really care because the clients were advised anyway, and he just has to witness the signature. And it's unbelievable, but we've seen this 3 occasions over the last, and we're talking about a nightmare. So you never mention a trust on a Spanish will. And the fact that everyone allows you to do it doesn't mean that later on it's going to make sense, because the notary just witnesses to make sure that what you're signing has been signed by you, and the advisor may have disappeared. So maybe a good piece of advice here is always ask your lawyer whether the will that he's prepared for you is, if he has ever gone to probate and got tax clearance on the will with the same wording. That's probably the best piece of advice here. Manage will. Okay, and that goes on to number 11, which is make sure your solicitor has plenty of experience with probate and the Spanish inheritance tax office. If he does not, he is not the correct person to prepare your will. Now, why do I say this? All solicitors in Spain that handle conveyancing will also can also draft a will. But there are many more solicitors that draft wills than those that handle probate. That requires a lot more expertise. So what I would suggest is, if you have 2 lawyers and they're charging a similar amount, use the lawyer that is used to dealing with lots of probate work and dealing with the inheritance tax office. That would be the word. But most people don't need any complicated wills, so the lawyer that handles the conveyance will do a will for them, and that will definitely, 90% of the cases, it will work well. But if you haven't made a will before and you're going to make a new will, it's best to choose someone that actually handles probate and inheritance. And if they offer you a will that looks a bit out of the ordinary, that is slightly complex, then definitely ask them whether they've ever gone to probate on a will exactly the same as that one, because otherwise you can have problems in the future. Okay, and finally, let's go to the 2 bonus tips. We've done the 11, and we're going to go slightly outside the business of wills. Now, the reason I say we're going to go outside is that often in our office, what we have is clients coming to us. They're at a certain age, they're getting old, sometimes they come along with their children, and they're just sort of working out, we're getting old, we start to feel a bit, the odd thing going wrong. And they just want to say, they're asking, the question basically is, what should we be thinking about to have things more or less in good order, so that one day, hopefully well in the future, we pass away, or we get very ill, or my wife or my husband has Alzheimer, in the future. What should we be thinking about? Okay, well, we always say to make the will, to make the Spanish will, to make sure it's in good order, just check through it to make sure it's good. And if it needs updating, go ahead and get it done. If you haven't done a will, definitely do one without any doubt. I always say if it's better that if they have an English will as well, to bring it into the office, so I can just have a quick look and make sure that they work together correctly. And then if it's a couple, and let's say they're 70 and getting on, another thing that we recommend, it's not in the same degree of importance as the will, okay? But if you want to leave things in good order, a total general reciprocal power of attorney between the 2 spouses is a very good idea as you get older. Now, the reason is that, let's say that going forward, one of the members becomes, is diagnosed with Alzheimer, and they're okay at that moment in time, but obviously we all know that going forward, hopefully many years, they will finally at the end lose the capacity of consent. Now, this in Spain can be an absolute mess if you haven't left a power of attorney, for example, with your other spouse. Why? Let's say, and let's just, for example, Joe and Mary, they have a villa worth 300,000 and a bank account and a car. Now, Mary is diagnosed with Alzheimer. And at the beginning, there's no problem, because if they had a buyer for the property, they wanted to sell it, they could just go in together, and she still has consent, she knows what she's doing, she could sign the sale, no problem. But what happens if they don't do anything? And then 10 years later, she is now in a home Joe can't live on his own anymore. He wants to go back to the UK, and suddenly they're in a situation where they need to sell the villa. And of course, they can't, because Joe's okay, he could sign the sale, but Mary, when she goes to the notary says, "You're not well, you've got no consent, you cannot sign the sale of the property." That's a mess, because to solution that problem, we'd have to go to court and get an incapacitation order. In Spain, that could take a year or two. It's very costly, and has some very frustrating cross-examinations by doctors. It's all very complicated. If they had the power of attorney, Joe would go in, he'd sign the sale, and then he can take care of the home's fees, or go back to the UK and have liberty. If it's not a question of a couple, but instead, just say, for example, the widow or the widower on his or her own, we always say that if their relationship with their children is good, to perhaps call them over to Spain. We have a family meeting, and we recommend that they maybe leave a total power of attorney with their son, with their daughter, or they can do, if there's not 100% trust, to perhaps leave a joint power of attorney between them, so that both children have to sign anything that's important, like the sale of the property and things like this. This avoids lots of problems. We see it over and over again, the situation where clients, the widow or the widower needs to sell the property and they can't, they're trapped. Okay, so the next thing I was going to explain is something that may seem very, very sort of obvious, but we always say that it's a good idea. When we're having that meeting, with the couple, are getting older, just wants to leave everything in good order, we always tell them to basically just locate their title deed to their property, to write down somewhere, keep a copy of it somewhere. They also need to have written down where their bank accounts are, in what bank. It doesn't matter if you don't know the branch, or if you need to know what the bank is, what company to write to. Sometimes people have an account off in Jersey or the Isle of Man, and sometimes nobody knows where it is. Now, there are situations where people, money can get unclaimed because nobody knows where to find it. So it seems very simple, seems it's not important, but it is. So we always say, the normal scenario is just locate your title deed and leave a photocopy somewhere, locate where your bank accounts are. If you've got a life insurance policy, put a note down and keep it all together. In our case, where we sign the wills, we also like to keep a photocopy, at least of the title deed and the most important things, on our filing system together with the wills. It's very convenient, but it doesn't have to be with a solicitor. You could also leave a copy just somewhere where your beneficiaries know where they are. It does happen. Money can go unclaimed. Sometimes people are over in Spain and their children don't go to see them very often because they're over in London or wherever, and then nobody can find out where the assets are. So there are things that are very easy. For example, on the property, there'll be direct debits, so we can lead back to where that account is. But what if there's another account somewhere else? People need to know. Okay, when there's a married couple, it's not so bad, because normally the surviving partner will be able to locate things, but sometimes it's not always the case. In other words, and sometimes there are even situations, and we've come across it before, where the spouse wasn't aware of certain accounts that their husband or wife had, and that's a dangerous situation, because it could lead to us not locating them. Okay. Well, that's it. I hope you found this useful. As I say, my name is Michael Davies. I'm a Spanish lawyer. I have 25 years experience handling inheritance and probate. We have offices in Almeria City, Majaca, and Marbella. We can help you with wills anywhere in Andalusia, and we can help you with inheritance and probate procedures anywhere in Spain. If you needed wills handling outside the region of Andalusia, we may not be cost efficient, because obviously, for example, if you had to go to Madrid just to organize one will, it wouldn't be cost efficient. But inheritance, we can be cost efficient anywhere in Spain. But anyway, if you needed help with a will outside of Andalusia, we can always direct you to a solicitor in that region, because we we get on very well with quite a few outside of Andalusia. So if you need to contact us, just Google davissolicitors.com, and that's it. And any questions you have, you can just email them directly to me from the website, and we take things from there. Thank you very much for watching, and that's it. Remember to have a Spanish word. Thank you.